Vishaka versus State of Rajasthan, 1997, 6 SCC 241. Summary and analysis. So the background of the case, rather we can say facts of the case, a woman named Bhavri Devi from Bateri, Rajasthan, was employed as a Sathi, his friend, under the Women's Development Project, that is WDP, run by the government of Rajasthan in the year 1985. In 1987, she gained the full support for taking up the issues of attempted rape of a woman from a neighboring village. She again took up an issue of a child marriage in 1992, where she failed to draw confidence and support of the people, even though they were aware of the fact that the child marriage is illegal. Abiding by the work assigned to her, she failed to explain the family to prevent the marriage. The intervention of the authorities failed, the marriage was held, and she was boycotted from the village as they believed it was her action which brought the police into the scene. She lost her job. Amid this boycott, to take revenge, 5 men attacked her husband and later brutally gang raped her. The police officials did not take convergent steps to file a complaint and the investigation was delayed. Later, with her firm determination to get justice, she filed the complaint. The medical examination was delayed for 52 hours with the fact that there was no mention of a commission of rape in the report. All the accused were acquitted in the case due to the lack of sufficient evidence in the trial court, which backfired the authorities and the judicial system from the different activists and the organizations, which resulted in filing of public interest litigation (PL) by women's rights group known as Vishaka. The PL drew attention on the enforcement of the fundamental rights of women at the workplace under the provisions of Article 14, 15, 19 and 21 of the Indian Constitution, coupled with the issues of the need for protection of women from sexual harassment at workplace. A 3-judges bench consisting of the then Chief Justice of India, J.S. Verma, and 2 others sitting judges, Justice Sujata B. Manohar and Justice B. N. Kripal, was constituted to hear the PL and decide on the same. The court appointed 3 amicus curiae, Fali S. Nariman, Mrs. Naina Kapoor, and Mrs. Meenakshi, to assist the Honorable Court in dealing with the case. Then issues raised in the case of Vishaka versus State of Rajasthan. The issues which were raised before the Honorable Court in the case of Vishaka versus State of Rajasthan are: first, whether the sexual harassment at a workplace amounts to a violation of the fundamental rights. Second, whether sexual harassment at workplace amounts to violation of the rights of a gender inequality. Third, whether the courts are entitled to use the international laws in absence of any specific gender rights and gender inequality law. And fourth, whether the employer possesses any responsibility for the sexual harassment faced by its employees at the workplace. So these are 4 important issues. Then we'll see about the arguments from petitioner side. In this instant case of Vishaka and others versus State of Rajasthan, the petitioner filed a writ petition seeking the writ mandamus. This is the case of mandamus. Mandamus by Vishaka group consisting of various women's rights activists, NGOs, and other social activists their argument that the incident acts of a sexual harassment of women at workplace violate the fundamental rights contained under Article 14, 15, 19, 1G and Article 21 of the Constitution of India. The petitioners draw attention of the Honorable Court to the existing loophole that the legislation has regarding the provision of a safe working environment for women. They requested the Honorable Court to frame a guidelines for prevent sexual harassment at workplace. Then next, arguments for the defendants. The Lieutenant Solicitor General appearing on behalf of the respondents did something unusual. He supported the respondent. He assisted the court in decoding a straitjacket formula to build a structure for curbing out sexual harassment and framing a guidelines for preventing sexual harassment at workplaces. The last point, judgment of Vishaka and versus State of Rajasthan. The lack of a law to prevent a sexual harassment at a workplace was acknowledged by the Honorable Supreme Court of India. The court realized the need for a proper and effective legislation that would deal with the sexual harassment, as Section 354 and Section 354A of IPC 1860 were not sufficient to deal with the issues in questions. The court took a reference from the international conventions to proceed with this case. It referred to the measuring statement of principles on the independence of the judiciary in the Lucia region, as well as the provisions of the conventions on the elimination of all forms of discrimination against women, that is CEDAW. Article 11.1a and 11.1f prescribes the state to take all the appropriate measures to eliminate the discriminations against a woman in the field of employment. Article 24 states that the state shall undertake to adopt all necessary measures at the national level aimed at achieving the full realization. The Supreme Court framed the guidelines to prevent the sexual harassment at a workplace known as Vishaka guidelines. These guidelines were the foundation for the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. Vishaka Guidelines of 1997. The court framed the guidelines in the instance case of Vishaka versus State of Rajasthan as: first, the employers should take all the reasonable steps to prevent the happening of a sexual harassment at the workplace. It is the responsibility of the employer to prescribe the mechanism to redress the sexual harassment, if any, takes place in the organization. Second, the Vishaka guidelines define the sexual harassment as disagreeable sexually determined behavior, direct or indirect, in the form of physical contact and advances, a demand or a request for sexual favors, sexually colored remarks, showing of pornography, any other unwelcome physical, verbal or non-verbal conduct of a sexual nature. Third, the preventive measures for the employers to be taken as prescribed by the court in this instance cases were in the following nature. First, the employer must take effective steps of preventing sexual harassment at workplaces. This has to be done by putting up notifications, circulars, penalties for the offenders as fixed by the government, adequate working conditions of health, hygiene, and the rest of the women workers. Second, the employers are bound to take action of complaining in the appropriate authority against the offender by bringing him into the book for the offences committing falling under the sections 354 and 354A of IPC 1860. If the employee does not act contrary to the rules for the prevention, the employer is bound to take a disciplinary actions against him. Every employer is bound to set up a redressal mechanism to deal with the issues preventing sexual harassment at workplaces. It is immaterial as to whether the evil act falls within the purview of IPC or not. A redressal committee must be set up with its head being a woman. It must have half of the members as women members. It is mandatory to send us an annual report to the government in relation to the conduction of its affairs within the organization. Last, the employers are also directed to spread awareness to prevent the occurrence of a sexual harassment at workplaces. So in conclusion, the judgment of Vishaka and others versus State of Rajasthan led the court to once again uphold the constitutional principles of equality and liberty. The judgment brought a ray of hope among all the women workers who were facing severe sexual violence, harassment, as well as a gender inequality prevailing in the then scenario. The Vishaka guidelines constituted the bedrock for the passages and enforces of the Sexual Harassment of Women at Workplace Prevention and Prohibition and Redressal Act 2013. Thank you very much for watching this video.